can you please call the hearing number for the record?
This is hearing number 31 of Monday, 6 January 2020, in the case of 001, Dorothy Chung Him et al., case 0022, Olivia Vincent, case 0031, Sharon Morgan, case 0032, Sylvette Morgan, case 0033, Derek Morgan, and case 0050, Jessie Laporte.
Thank you. Prior to calling the first witness, we have some announcements we would like to make. The first is to recall the objectives of this Truth, Reconciliation and National Unity Commission. The Commission, through its investigations and determinations of complaints of allegations of human rights violations related to the coup d'etat of 1977, is to determine the truth of those allegations, create an objective public record of those violations, help bridge divisions caused by any violations, provide closure for the victims and perpetrators of the violations, determine the appropriate reparations for victims, the appropriate rehabilitation for victims and perpetrators, and whether or not to grant amnesty to persons the Commission determines responsible for human rights violations. Ultimately, through its work, the Commission's objective is to unite the people of Seychelles around a common agenda that will help them move forward in confidence and with a sense of common purpose, and ensure that such violations do not recur. In everything it does, the Commission is to adhere fully to international human rights norms and appropriate international fair trial standards, and demonstrate respect for the right to dignity of suspects, perpetrators, victims, and witnesses. The Commission is required to carry out its functions in an open, impartial, and transparent manner, and to be accountable for its actions. Having set out the Commission's objectives, the Commission would like to make a few comments. First, the Commission is acutely aware that attacks upon its impartiality are easily made. For example, the Commission has been accused on social media of partiality, both because it has heard evidence from persons supportive of the coup d'etat and the one-party state that followed, and from persons who were opposed to the coup d'etat and were alleged victims of the one-party state. As the Commission has previously emphasised, primarily its concern and its focus is determining the truth of allegations of human rights violations brought by complainants in relation to the coup d'etat. But it must be understood that those violations did not occur in a vacuum. They occurred in a context, and the Commission needs to understand that context if it is to achieve its objective of ensuring that such violations do not recur in the future. Moreover, the Commission needs to understand the source of division between the people of Seychelles if it is going to help try and bridge the divisions caused by those violations. Accordingly, the Commission's hearing and consideration of evidence of persons holding conflicting views of the coup d'etat of 1977 and the one-party state that followed is a necessary part of the work of the Commission. It enables the Commission to determine the truth of what occurred and why. Importantly, the Commission can only achieve its ambitious objectives with the cooperation of the people of Seychelles, and that includes cooperation of those persons who are following the work of the Commission and providing their commentary of that work on social media. The Commission respects the right of all persons to hold opinions about its work, but it reiterates its request that all persons are respectful of the Commission and are in particular respectful of persons appearing before the Commission, whether they be complainants, witnesses, or alleged suspects of human rights violations. The Commission has a difficult task, made even more difficult if persons with relevant information are dissuaded from coming forward because of the fear of derogatory commentary on social media, or a fear of being shunned by the broader community should they take responsibility for their role in human rights violations. Fear of criticism on social media is also a basis upon which more and more witnesses are requesting to be heard in closed session, which is against the broader public interest of transparency in the work of the Commission. The Commission calls upon those persons using social media to devote their energies to supporting the work of the Commission and supporting its objective of reconciling people in Seychelles, rather than impugning its integrity and that of persons appearing before it. Next, the Commission would like to remind all complainants that they have until 9th of February 2020 to request the Commission to take up their complaint. They can do that by phone, email, or by visiting the premises of the Commission. Unfortunately, the Commission has at times experienced technical issues with its email server. So if you have contacted the Commission but have received no response, my apologies, but we may not have received your email. Please email the Commission again. The Commission would also like to assure all persons that are coming before it that fear retaliation that the Commission is committed to a robust system of witness protection. The Commission cooperates with the police in this regard, and it is recruiting a witness protection officer to work with the Commission to further bolster its system of witness protection. The Commission is confident that persons appearing before it can rest assured that they will receive what protection they need. Finally, the Commission wishes to remind all persons coming before it of the prohibition of making allegations against a person who has not previously been given the opportunity to respond to that allegation. The making of an allegation without previously giving the person impugned the right to respond violates the due process rights of that person. Moreover, the Commission stresses again that witnesses should only give evidence to the Commission of that which they reasonably know to be true, and should refrain from making unfounded allegations, particularly when they are irrelevant to the determination of the complaint made. The making of unfounded and irrelevant allegations hinders the work of the Commission and undermines its objective of reconciling the people of Seychelles. I thank you for your attention, and at the end of our hearings today, the Vice Chair will provide a Creole version of these remarks. Thank you. Could you now call the first witness, please?
Mr. Stephen Knight.
Maybe some water, yeah. Thank you, Mr. Knights, for appearing before the Commission today on behalf of the Attorney General. We're very grateful to you. The Commission has called you because there has been some concern, and indeed a couple of persons that have been called to give evidence have expressed the concern, and that is the impact. It's been called the Seychelles Government's Official Secrets Act, but I think it's the is it the State Security Act?
Yes, it is the State Security Act.
So the impact of that act on the evidence of witnesses and suspects before the Commission. So the Commission is concerned that witnesses and suspects are not providing information within their possession concerning gross violations of human rights that occurred during or in relation to the coup d'etat of 1977 because of concerns of violating obligations imposed under the State Security Act. So the Commission would be really grateful to receive your advice, and so that everybody can hear what the impact of that act may be or may not be on witnesses and suspects from providing full disclosure before the Commission. So the floor is yours. Thank you.
Okay. Thank you, Madam Chair. The Act is the State Security Act, Chapter 229 of the Laws of Seychelles, Revised Edition 2010. But before I proceed, Madam Chair, can you kindly indicate, without stating the name of any person, when did someone refuse to give information? Because for us, we would have a better understanding of the circumstances, and we'd be in a better position to advise.
I mean, it's even in relation to education policies, policies in government departments. So there has been a couple of occasions where it's in someone, oh, you could tell us about some policies or what the policies of the department were, and it's been in relation to that. We had one person tell us, I can't remember what in relation it was. Even in relation, just government policies, that's all I can really remember. It's been broad, very broad-based. Yeah.
Okay. Well, first of all, I will look at the history of the Act so that everyone can have an idea.
So the Act was passed in 1978, is that right?
No.
No?
It is Act number 16 of 1977. It was assented by President James R. Macham on the 20th of May, 1977. It became effective, or it came into operation, on the 10th of January, 1978, by SI number 3 of 1978. Now, the long title of the Act reads, "An Act to make provision relating to state security, to deal with espionage and other activities prejudicial to the interests of the state, and to provide for matters incidental thereto and connected thereto." Now, another important point to note is that this Act was never amended. So, over the course of a period of time, what generally happens, as you may know, Madam Chair, also being an attorney, is that you would have law revision. Now, in this Act, Section 2 had a commencement provision which read, "This Act shall come into operation on such date as the President may by order appoint." And if you look in the current law, what you will see is that Section 2 is no longer there because after the SI was drafted and signed, there's no need for this provision any longer. The relevant provisions to this commission with respect of someone coming before the commission and saying that we cannot give you information because of the state secret is sections 3 and 4. Originally, it was sections 4 and 5, but since we remove section 2, it's now 3 and 4. 4 and 5. 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 4 77. Now, Commissioners, the Act, well, the sections rather, sections 3 to 4, it runs for about 8 pages. So I will briefly summarize what the content therein is. So basically, these two sections provides for offenses, which would include communicating state secrets without authorization, receiving state secrets without authorization, keeping materials that is state secret after you stop working for the state or you're no longer an official of the state, and espionage. For example, the law prohibits any person who has state secrets from giving or obtaining military, political, commercial, or other secret information to, let's say, a spy or someone of that nature. Now, in short, anyone who unlawfully communicates, unlawfully receives, or unlawfully shares a state secret can be liable of an offense. And this anyone can also include a commissioner. And I will explain this a little shorter. Now, in terms of the penalties on this act, well, rather these two sections, ranges between 2 years and 14 years of imprisonment. Every public officer, before he or she begins to work for government, is given notice of this law. I can share a copy of the official secrets declaration with you if you would like. Thank you.
I have a burning question.
Yes.
What is a state secret? Yeah.
Well, it would be something that would be prejudicial to the security of the state.
Is it defined in
It's
this
not.
act?
It's not defined in the act.
Oh, really?
No, it's not. It's not defined what is.
What is a state secret?
No. Well, the thing is, certain information that comes before your knowledge, you are not permitted to disclose or share such information without authorization from your department or whatever ministry you're part of.
I just hypothetically,
Yes.
let's say I'm working in the Ministry of Lands and we have a policy where we're going to just take footpaths and take roads off of private persons without letting them know. We're just going to steal a little bit of land. Let's say that was my policy. Could I say this is my secret policy? This is in the interests of the state. It's a secret, can't disclose it. Would that be a state secret? If I decided as the Minister of Lands that was my policy, that's what I was going to do in the interests of the Greater Seychelles, would that be secret?
Well, I wouldn't go into answering that hypothetical question. There's certain information, for instance, if even a cabinet paper is something that I would not be able to disclose to you. So there's certain obligations on each and every public officer with respect to not sharing certain information.
Are all cabinet papers secret?
Unless you have authorization to disclose it, it is confidential. Now, under the
Excuse me,
yes,
is confidential taken to be synonymous with secret?
what do you think?
Not necessarily.
Okay.
On some documents, I have seen top secret, confidential, classified.
Okay.
So what do all those things mean exactly in the context of the State Security Act? Because for me, it's quite confusing.
Okay.
Sometimes you can see confidential in red. Yes. You see top secret. You see also recital circulation. And sometimes I say classified. So for me, it's a really complicated language to understand. Now, you said also at the beginning, any official being appointed should be informed about the act. Am I
Yes,
correct?
and I was now about to read the official secrets declaration.
Thank you.
So, if a public officer is here and he or she is uncertain as to whether or not the information is a state secret, that person should contact or communicate with the department, and then that person can move forward. So I'll just go through the declaration here. My attention has been drawn to the provisions of the State Security Act 1977, Section 5, which set out on the back of this document, and I'm fully aware of the serious consequences which may follow any breach of these provisions. I understand that this section of the State Security Act 1977 covers materials published at home or overseas in a speech, lecture, or radio or television broadcast, or in the press or in book form. I am aware that I should not divulge any information gained by me as a result of my appointment to any unauthorized person, either orally or in writing without previous official sanction in writing of the ministry or department appointing me, to which written application should be made and 2 copies of the proposed publication be forwarded. I understand also that I am liable to be prosecuted if I publish without official sanction any information I may acquire in the course of my tenure of an official appointment, or retain without official sanction any sketch, plan, photograph, model, cipher, note, document, or article which is no longer needed for my official duties, and that these provisions may not only during the period of my appointment, but also my appointment has ceased.
Can I just ask another question? I mean,
Yes.
pursuant to, let's say somebody came here
Yes.
and they decided to tell us something that was maybe secret. They didn't get authorization, right? So maybe they want to tell us about something. Our proceedings, Section 10 says evidence given before the Commission shall not be admissible in any civil or criminal proceedings other than in prosecution for perjury.
Yes.
So would that prevent them from being able to be prosecuted by the Attorney General for telling us state secrets?
Madam Chair, I'm going to answer that question shortly, because I am of the opinion that this commission can hear state secrets. And yes. Okay. Now, I wish to draw the Commission's attention to Section 15 of the State Security Act. But even before doing so, I would also like to remind you that under Section 8, subsection 3 of the Truth, Reconciliation and National Unity Commissions Act, it reads, "For the purposes of effectively exercising its functions and powers, the Commission is hereby vested with all powers and rights of the Supreme Court." Now, if you look at Section 15 of the State Security Act, it reads, "At any time before or during the hearing before a court of an application or other proceedings, whether in pursuance of this act or otherwise. The judge or magistrate or other person presiding or competent to preside over the proceedings may, if satisfied that such a course is expedient in the interest of the defense of the Republic, A, order that some or all of the members of the public shall be excluded during the whole or part of the hearing of the application or proceeding. So in other words, you can tell everyone who cannot hear a state secret to leave the room. Secondly, which is B, order that no report of the whole or a specified part of or relating to the application or proceeding shall be published. Now, I've noted that in Section 6(7) of your Act, it says that the Commission shall keep and maintain complete written records of the proceedings, and it goes forward. But in my respectful opinion, this can be seen as an exception to making that information public. C, make such order and give such directions as he thinks, which is the Commission thinks, for ensuring that no person without the approval of the court has access either before, during, or after the hearing of the application or the proceedings to any affidavit, exhibit, information, or other document used in the application or the proceedings that is on the file in the court or on the records of the court. And it also provides a penalty for anyone who does not abide by these orders. Now, do you want me to go back to your question with respect of whether someone comes before this commission and gives information? Now, the law says information used before the commission. Now, it doesn't exclude the Attorney General from getting information outside of the commission to prosecute someone. Agreed. Likewise, if a state secret is communicated to a commissioner, and that commissioner acts outside the scope of the act, or not in the furtherance of the commission, then I don't think you can be protected by this act.
So if I learned a state secret and then I took that state secret and did something detrimental to the, is that what you mean, or?
Yeah, so if you during a proceeding decided to send everyone out of here and then just you and the person here, and then you receive that secret.
Can I just clarify,
Yes.
do I have to send everyone out of the room? If someone comes, how do I know it's a state secret? And do I have to make sure it's not made public? Because they won't be prosecuted, right? Because they're saying it in here.
Well, it depends. As I said before,
If they just say it
if we
here.
gather, if the Attorney General is able to gather information outside of the commission, then that's a different story.
If it was just the person said it here under the protection of the Commissions Act and didn't say a word outside the commission, it would be difficult, no?
Yes, but I also think you have a responsibility as well as the commissioners to
But we don't.
not allow
yeah.
certain secrets to come out. So
But what's a state secret?
yes, it would be something that would be.
That's our problem. Since you said it is not defined in the Act, how do we know precisely what is a state secret and what is not?
Could I exclude from state secrets any gross violations of human rights? Could I exclude that from actually being a state? Let's say there was or evidence of people being mistreated to get rid of them out of the country because they were detrimental to the stable order of this country, a bit like torture. Would that be a state secret that I could say that's not a secret because it's a gross violation of human rights and the Commission's objective is to determine the truth of these allegations, even though at the time it was maybe a secret?
Yeah, so the thing, again, if you look at Section 15, it is in the interest of the defense of the Republic. I am also aware, I think this law is almost in every other country. Yes, it's also in Australia because I was looking at I think it's the
It's a
Crimes
normal
Act.
law.
Yes,
It's a normal law.
It's a normal law. Unfortunately, it's not defined, and I don't want to give you a definition of what a state secret is. Also, for me, if I'm an individual and I'm before this commission and I'm unsure as to whether I'm going to incriminate myself, I would rely, I think it's maybe section is it?
But you could
Section
just make
13,
a full and
section-
frank disclosure and a sincere apology and petition for an amnesty.
Yes, but there are other ways, as I said, outside of the commission that someone can be prosecuted.
Just want to clarify, let's say somebody comes before the commission and confesses that they were responsible for all these gross violations of human rights and they're really sorry for that and the commission determines, yeah, you were responsible and your apology is sincere. Under our act it says we shall grant an amnesty. The Attorney General wouldn't then seek to prosecute that person.
No, madam. Under the act as well, I think before you come, you need to have an affidavit, right? Is it before? And it
Yes.
has to be done by way of an affidavit?
Yes.
Yes? So once the procedures are followed.
Just want to make sure for those persons that may be thinking about coming and telling us what they've done, that that's not going to expose them to a legal process if they're in an amnesty process.
No, there's a clear procedure that is set out in the Act as to how amnesty is granted. So I think it would be the responsibility of the commissioners to follow that. I would also want to highlight to you as well that you can also obtain written copies or hard copies of any state secret, and this would be on the section 8.2b, which provides that the commission may have access to public or private archives regardless of restrictions contained in the laws of Seychelles and may make copies of any documents found therein. So if someone comes before you and they tell you about a document, you can inquire at any of the departments or ministries so that you can have access to it. But again, you need to act responsibly with whatever information you have. My instructions are that if someone acts in contravention of the law, then the Attorney General will have to seek to enforce the law.
But he'd have to get evidence outside what was heard in this commission, information outside what was heard in this commission to pursue somebody.
Yes, but again, Madam Chair, as I said, if there's certain information that would be prejudicial to the state, the Commission should act responsibly and ensure that such information is not made publicly immediately, because you can send the person, you can send everyone out, you can hear it, and then you can bring the person back in if you consider that it's not prejudicial. There is also a well, there are a number of UK cases that sets out the procedures for such hearings. I also noted that in Seychelles, there was a recent case, All Value Bank versus Central Bank of Seychelles, 2018, SLR 37, before the Court of Appeal, where the issue was accessing confidential information, and the court sets out the procedure. Also on the Section 82E of the Truth and Reconciliation and National Unity Commission Act, the Commission can seek guidance from the judiciary as to how it can go about these proceedings.
Okay, so if I think what I get from what you're telling me is that we have to be responsible, number one. But if I ask somebody to come, if they have concerns, they should seek authorization from the relevant government body as to whether or not they can disclose the information the Commission is trying to get from them. If that information disclosure publicly could be prejudicial to Seychelles, we should hear it in closed session and not disclose it publicly right away, and only disclose it if we determine that actually in context it's not prejudicial.
Yes, and of course when you have a witness here, I mean, you're probably the only attorney on the panel, but when you have a witness, you would be aware that you still have to control that witness. So if you are asking questions and you're seeing that a witness is going down a certain line and that witness is making statements that is not acceptable for a court, or basically you can stop that witness.
You know, it's the Commission, you know, it's difficult for the Commission because we're talking about people coming before it that have had for 40 plus years, many of them, no forum to express themselves and what has happened to them. So, you know, we have a lot of patience with allowing people just to get rid of the burden they've been, you know, carrying. And sometimes they do go a little over the place, you know, but it's a process. And I'm very respectful of a person's individual process. Our role is to make people feel better about what happened and to try and reconcile people. We're not a court, you know, we're not punitive. We're trying to create an environment which brings people together and where people feel better, not worse. So we're quite lenient, I think, you know, because we see to be respectful of somebody is to allow them to be heard when they've been denied that right for so long, you know. So,
well, Madam Chair, respectfully, the Commission has a mandate, right? And if someone comes before the Commission and that person is running on a frolic of his or her own, I think you would have some responsibility in controlling that person and getting that person back on track with respect to providing the Commission with information that is relevant to the purpose and mandate of the Commission. You just can't have someone come and speak about something that is not relevant to the Commission.
I mean, we
do
emphasise that. We ask people to only tell us that which they reasonably know to be true, not to make unfounded allegations and not to make allegations that are irrelevant to the complaint. I mean, we do provide that guidance. And we, again, this morning, we provided that guidance to people coming before the Commission.
Okay. And also the state secrets, I want to also add that the secrets must be relevant to the coup d'etat and relevant to your mandate. So if you have no further questions, I think this would be the extent of my assistance to the Commission.
If sometime in the past person was given instructions to commit a criminal offense, let's say like torturing somebody or even killing somebody by somebody in government, would that be classified as a state secret?
If someone was given instructions to kill someone, I think that might be an offense. More
That's
or
right.
less, yes. So that wouldn't be a state secret.
Thank you.
So I think more broadly, I would exclude human rights violations from being, gross violations of human rights from being a state secret.
Yes, I don't think that is prejudicial to the state. But there's certain information about plans and so forth that you may not be able to just allow it to be heard just like that. So you can just, so as to just ensure that certain information doesn't get out without you probably verifying. Because you, as I said, if you find that, look, this information can be disclosed, then fine. You have the powers under the Act.
I still believe that there's the serious need to train the public officers, even those in a high rank position, to understand clearly how they can apply the Actual Information Act in Seychelles against the State Security Act, because for me there's a big problem. We say the people have access to information on one side, the other side we say we have state secret. I understand. You said military, political, commercial, etc. So I think if I'm a PS or a CEO in high position, I should be trained even to understand the differences. Am I right?
Yes.
Thank you.
So there's the Freedom of Information Act that was recently passed in Seychelles. Even under that act, there are restrictions in terms of what information someone can get. So this is not something that is novel. It is something that is across the board in several other countries.
Thank you very much, Mr. Knights. You've been very helpful. I think you've clarified things for me. I hope you've clarified things more broadly, especially for the general public, so they understand. We really appreciate you coming. Thank you very much for the attorney. We have no more questions for you, so unless you have a question for us.
No, Madam Chair, I do not have any more questions for the commissioners. Should you need any further assistance from the Attorney General's office, we would be willing to provide such assistance. And as you are aware, under Section 6 of your Act, this is just an opinion, and you're not bound by the opinion of the Attorney General. And of course, you're free to solicit another opinion on the interpretation of the relevant sections. Yes.
Thank you. Thank you very much. Thank you. Okay. All right. Our next witness will be in closed session. So we will adjourn now and return in public session at 1 p.m. today. Thank you.
All rise.